received on October 7th, Governor Abbott issued a new executive order. This is GA 32, and it deals with the allowing of bars to open at 50% capacity starting October 14th. One of the guidance pieces was that he's encouraging the bars to close at 11 p.m. But this would only be effective in those regions that had hospital occupancies that were 15% or less than 15% of total occupancy would be COVID occupied. So just wanted to make you aware of that. Judge, you have any comments on this? Or
see, you can still see me smiling behind me.
Yes, sir, I can.
Yes, what the governor basically said is that you could open them back, but it was a decision of the county judge, and it wasn't actually done by an order. It was done by notifying PABC that the county was going to be, the county judge was going to allow the bars to reopen, and he issued that order on Wednesday, and I began talking with folks and continued talking with folks all the way up till about 3:30 yesterday when I announced that we were going to go ahead and reopen the bars. The folks that I talked with through that process were the hospitals, cities and mayors, some bar owners, as well as other businesses. I talked with my partners here on the court. And I guess what I would simply say is from the very beginning until now, and will continue throughout the process for however long this goes on, was a focus on the hospitals and the ability to keep the hospitals open. And after communicating with the hospital CEOs both last Friday as well as yesterday afternoon, they felt, and I listened, and they felt like that they were in good shape, that yes, there had been some uptick, but that they still felt very comfortable in their abilities to keep the hospitals open in Tarrant County. Now, the ratio that was talked about, the 15% that was mentioned a moment ago, is for the region, the trauma region. I'm going to focus more, as I look at this, on Tarrant County. And as I notified TABC that we were going to allow the bars to open, I can just as easily today or tomorrow or any day from here on out basically notify TABC that we are going to close the bars. Last evening, about 5:30, I met with about somewhere between 35 and 40 of the local bar owners and explained to them the decision and how I got to the decision, and the fact that while in the past, as we've looked at enforcement, the goal has been not to be out there issuing citations all over the place, but to encourage folks and warn folks that if they continue to disregard the orders, that we might issue a citation. When it came to this part of the deal, I talked again with the cities and with the mayors and said that in order for me to do this, we were going to have to become much stronger on the enforcement side. Now, there's two sets of enforcements. We currently have mask policies. That I have a mask policy that pertains to businesses. The governor has a mask policy that pertains to individuals. And I have the assurances of several of the cities, the mayors, and the police that they're going to go out and take a much stronger position in enforcing those mask orders, and those can be citations if folks choose not to do as we have asked. Then the fire, the police, and the ordinance folks can issue citations, and those citations will range anywhere from $250 up to $1,000 per occurrence. If they choose not to follow, the TABC can also come in, and if they're not following those orders, they can suspend their liquor license. Obviously, that's much more effective, because if they suspend their liquor license, that's where they make most of their dollars, and so they're not going to be very anxious about having that happen. And so I just explained to the individuals that I felt like that many of the folks who we were opening up and who had remained closed did not try to find the loophole to get through that and continue to operate as a restaurant. And so I felt like to not open it was to penalize those who were trying to follow the orders in most instances, and not the folks who had found the loopholes and were opened up and potentially violating the orders. I had a lot of folks refer me to the WFAA video this past weekend of the Varsity Tavern, and what appeared to be a very blatant disregard for the orders. That owner was at the meeting that I had, and I specifically indicated to him that if I had the authority, I'd pull his license yesterday, and will continue to try to pull it today and tomorrow and the next day if they choose to continue to disregard the orders. He wasn't happy about that, but I mean it that way, and I said it to all of them. We're going to try to open it up, but at the same time, we're not going to let everybody just blatantly disregard the orders. So that's kind of where we are right now. I want to get businesses back open. I want to be sure and be careful about public health. My focus has and will remain the hospitals staying open. And in every decision I make, have made before, and will make maybe in the future, it'll always be done after talking with other folks who are in the community. My partners on the court, the cities, public health, the businesses, and other folks. And then again, I want to thank the DA's office, because they've been very helpful in making sure that we understand exactly what the governor's orders say. And it's the orders that he writes, not the other things that you may hear or read. And so that's the thing that we have to stay focused on. So with that, I'll be glad to answer any questions that anybody might have here, and if y'all have got any questions. But it wasn't an easy decision, but it was one that I think helps us to get the businesses back open and hopefully get our economy back going. And I will say this, as we talk about other things, I hope that if we do another round of economic grants, or that as we do them, that we include the bars in that. We excluded them this first time. There are a number we excluded them the first time. I was told that the bars were not eligible for application. If they were, then I misspoke, and we'll be more than glad. But it was my understanding that the bars were excluded out of the first round. You're saying no?
I don't believe they were, Your Honor. I think the only group that was excluded were the franchise.
No, I think the bars were.
The bars were excluded.
Yeah.
Okay, we'll check on that.
But I'm just saying, if they were or weren't, it doesn't make any difference. The first round is passed.
Yeah, the second round, we're opening it up to everybody.
And I hope that we open that up to everyone from that standpoint. Any questions?
Rep over the TABC. They did go to several of the bars that were open up, and some of those that are considered restaurants because of a loophole. And I was informed that there were 3 within the North Texas area that were going to be suspended for a 30-day period, 1 in Fort Worth, 2 in the Dallas area. I was told that late yesterday, and I'm not sure they've, that particular place in Tarrant County doesn't open up until Thursday, and at that point he had not had a chance to talk with the owner yet to inform him that he was losing his liquor license for 30 days. But so I don't want to mention the name until I know for sure that they've done that.
Yeah. And Your Honor, and members of the court, the fire marshal is he and his deputies will be out beginning in the latter part of this week and the first part of next week. We don't have that many bars that are in the unincorporated area, about 12 to 15, but we're going to do visual inspections on capacity issues and things like that. We want to make sure that those bars and those bar owners are fully aware of what the county's position is on all of those. So that's something that Randy Renoir did. He took that on right away, and we're making sure that those that are in our jurisdiction also receive the message.
Question for the DA's office. If he went into one of those places and they were not compliant if they're not compliant with the occupancy, I assume that he can ask them to leave and then only allow in the number of people to get to that occupancy level. What about masks? Can he write citations since we as a county don't have ordinance making authority? He is Randy Winraw, the fire marshal.
And the fire marshal has peace officer status, just like any sheriff's department people. So,
our recommendation to the fire marshal would be to go ahead and enforce what he can normally enforce, occupancy, and do what he can normally do. But to the extent that there's not social distancing or not wearing masks, that he report that to the TABC so that they can come in and do the enforcement.
So that partially, that told me what you thought. I mean, I guess it told me what you're recommending to him, but does he have the authority to write a citation citing them for not wearing the mask as is ordered by the governor and the institution or the business itself, a citation to them for not following my order?
I do not believe that he can write a citation for violation of your order or the governor's order.
Okay.
Who can?
Fort Worth Police Department can write citations for violations of the Fort Worth ordinance because they have in their ordinance that it is a $250 or $500 fine, but a violation of the county order or a violation of the governor's order is not something that is punishable by citation, other than the mask component in GA 29, which does allow citations to be written for not wearing a mask if you've received a warning. There are some concerns about that particular enforcement measure.
Well, we know they can get up and walk away if they want to.
Correct.
But if they don't walk away, are you saying that the governor's order is unenforceable in the unincorporated area?
For mask wearing?
Yes.
So there's two governor's orders in play, GA 29 and GA 32. GA 29 allows you to write a citation for not wearing a mask if you've been warned.
Okay.
If an enforcement officer feels comfortable doing that, then we can presume that that is valid. GA 32, a violation of that order cannot be enforced by a citation, is our interpretation of that. Because the offense is not a Class C misdemeanor.
Okay. I'm not sure I understand why you can write one under 29, but you can't write one under 30.
Because 29 expressly says that for violations of this order, GA 29, you can issue a citation after you've given a warning for $250 to the person who is not complying with that order. So it provides the authority.
So in that situation, if Randy warns somebody and then goes back in there and they still are not wearing one, or they refuse to wear one after his warning, and he writes the citation, where do they go to respond to that citation? Is it a JP, or is it would it be the JP?
I assume that there's instructions on the citation as to how you handle that citation. But yes, I would assume it is the JP.
JP is that precinct.
Oh, hey, Randy.
Okay. That's what I needed to know.
Thank you.
Thank you. Okay, take one machine, separate it away a little bit from all the ones that are very close together. And so those folks who choose not to wear masks can vote at that one, but that all the folks where the machines, I get, the constant complaint I get is, we're supposed to be social distancing, and I've got 2 or 3 people in line that are sitting there with no masks on. And as opposed to at least the ones that have masks on are in the machines that are not 6 feet apart. What you've said is that you've got 300 extra machines out. As a result of that, there is no way you can take a machine and separate it off. And I guess I would just, I've said I'm going to go by and visit some sites. I would ask that the commissioners in sites that are in your area. I mean, masks are obviously something that I believe in. I'm taking beatings over this every week. But if somebody is not wearing a mask, we can't tell them to. We can't prevent them from voting unless they do. But I would certainly like to see those a machine set up for them that does not, again, put them in the middle of folks who are wearing masks. That's just kind of where I'm at on that, and what I would hope that would happen.
Like I said, we've looked into it. To keep those lines short, we've added the equipment that we calculated we needed, and we're certainly right on the limit. The long lines are telling us already, we're right there in certain places, right? Some have shorter lines than others. So my point being, the only way it looks like, and I will start probably visiting those sites personally, but from the instruction that was given to the technicians, hardly any site has any room to create that one machine separated gap. I will go visit them personally, but if we can't, the question is, would this court want me to remove one to create a gap between the last one in the chain and everyone before them? That's probably the only thing that looks like we can do at this point.
It would certainly be my preference that everybody who voted wore a mask. But I am very sensitive to voting rights, protections, and equal protection under the law. I am not convinced that you can treat persons who don't wear a mask differently in the cause of voting than you treat people who wear a mask. That seems to me to bring up some constitutional problems. And it makes me nervous.
You might also find that a number of people who don't want to be jammed in that are wearing a mask would prefer to go use an isolated machine. I think it works both ways, and I don't see how you force or mandate somebody without a mask to go to that isolated machine.
I think it's at least questionable, to leave it at that.
If we're going to start,
I'm sure we'd get some push.
start defining law, then let's let the lawyers do it and not. If that's
I never purported to be practicing law.
Come on down.
I said I personally had a problem with it.
I think Commissioner Brooks raises valid concerns, and Ficus, it would not be the recommendation that we treat those wearing masks and not wearing masks to use different machines,
So
at least not to mandate it.
Because when I get the calls, I'm not going to say to them that the DA has said that we cannot set a machine aside for those folks who are choosing not to wear masks to vote, and that we can't we can't equate social distancing.
I think it would be more appropriate to say that we would not recommend it.
Well, that's not what I'm asking you, is what your recommendation is. I'm asking you what the law says.
You can do whatever you want, but we would not recommend it because it poses concerns about constitutional voting issues. So, is it possible to do it? Yes. But does it raise legal implications? Yes, which is why we would not recommend it.
Okay. Raises implications. I mean, usually you'll say, yes, you can do this, or no, you can't. But in this situation, I hear you kind of hedging your bet. I mean, you've opined that basically we can require the masks. A lot of people have said that violates my constitutional right. Your thought in that matter is, no, it doesn't. You've got the authority we interpret that you've got the authority under the law. So I'm just trying to figure out whether you're saying or not that if someone doesn't wear a mask, we're not telling them they can't wear a mask. They can't, if they're not wearing a mask, they can't vote. All we're saying is if you're choosing not to wear a mask, here's the place, here's the machine that you will, or the machines that you will vote on.
I think that any further discussion of this would be more appropriate in our closed session.
Okay. Then we'll set it up. I don't quite understand. I mean, it's either you're recommending or you're not.
I'm not recommending it.
Okay, then we'll just leave it right there. Anything else for Hyder at this time?
Yes. Hyder, will you talk a little bit about some